Hi guys, welcome to another reading comprehension session. Today we are going to do the various different types of reading comprehension questions. So I'm guessing you would already know those, right? We have universal, we have function, specific, detail, infer, and extrapolatory. So we're going to look at each one of them. Yeah, and we know that time just flows out of hand when you're doing reading comprehension. So that is why I'll share my screen right now. So governments of developing countries occasionally enter into economic development agreements with foreign investors who provide capital and technological expertise that may not be readily available in such countries. So what am I thinking over here? I'm saying, all right, let's say UCB is a developing country, right? So it does, there's a lot of, technologically it's not so advanced. There is a lot of way to go. And then there are other countries which are developed. Let's say one of them is UCA. So then UCB has some kind of agreements with some foreign investors, some investors in UCA, where these investors pump in money to basically, for example, say build bridges in UCB or make dams over there or make roads, etc. Right. So basically, some economic development agreements, right, or they could be trade agreements. Right? But then basically what they're saying is that governments of these countries, the developing countries, they may occasionally enter in economic development agreements with the foreign investors who provide capital and technological expertise. Now, it makes sense that these foreign investors will be from the more developed countries because that is how they can provide capital and technological expertise, right? They have to be technologically more advanced. Right? So, all right. Next slide. Besides the normal economic risk that accompanies such enterprises, investors face the additional risk that the host government may attempt unilaterally to change in its favor the terms of the agreement or even to terminate the agreement altogether and appropriate the project for itself. So, as we said that, for example, a foreign investor could have an agreement with a country to, say, build a dam. Now, what happens and electricity is generated and then sold, and then the foreign investor gets a part of the revenue, etc. Now, what happens if the government, the host government, let's say the government of UCB, it just appropriates the project for itself. That is, just takes away the project and it chucks out the people of the investors of UCS. It's possible, right? So that's what they're saying, that besides the normal economic risk, the normal economic risk is that when they produce electricity, people will not buy it or etc. Whatever the economic risks are of a business, when you invest somewhere, whatever are those, then there is an additional risk as well. And why? Because the governments can do anything, isn't it? The residents, they come under a law, but governments are usually a law of their own. So that is why, right? So then this is an additional risk that they face. All right, next line. Now, in order to make economic development agreements more attractive to investors, now this could be one of the reasons why investors wouldn't really want to have economic development agreements with the developing countries. But then they do need to make them more attractive. So what do the governments do? Some developing countries have attempted to strengthen the security of such agreements with clauses specifying that the agreements will be governed by the general principles of law recognized by civilized nations. So they're saying now that to make these agreements more attractive, what they have done is that they have, in such agreements, they have come out with clauses which specify that the agreements will be governed by something called the general principles of law recognized by civilized nations. So, when I come over here, I would assume that these would be, let's say, where they say that both of them have equal power and it like one the government cannot really check out the investors, etc. Right? So there'll be some general principles of law that are recognized by all the civilized nations, right? So a set of legal principles. Now they explain what these general principles of law are. A set of legal principles or rules shared by the world's major legal system. So these are the principles or rules that are shared by the world's major legal system. So most likely they will be well thought out and they will not be unfair to anybody. Now this is a little unfair in case the government, refuses to share the, let's say, the revenues with the investors later on, right? So then, of course, then these general principles would not be unfair, is what we can assume, right? So, however, advocates of government's freedom to modify or terminate such agreements. We're talking about people who advocate that governments have the freedom to modify or terminate such agreements. People who are in favor of that, who say that, governments do possess that power, right, argue that these agreements fall within a special class of contracts known as administrative contracts, a concept that originated in French law. So now these people who advocate the government's power, they say that the agreements that the government has with the investors, an agreement that a government makes, it falls in a special class of contracts. They're not like just ordinary contracts, right? The general contracts. They fall in a special class. They are known as administrative contracts, and it's a concept that originated in French law, is what they tell us. Okay. So what is special about these administrative contracts? Let's say they assert that under the theory of administrative contracts, a government retains inherent power to modify or terminate its own contract, and that this power indeed constitutes a general principle of law. So, what they're saying is that these contracts come under, they're called administrative contracts, they come under this terminology. And in administrative contracts, a government does have inherent power to modify or terminate. I mean, government does possess that power, and in fact this power, it is a part of the general principle of law. We talked about the general principles of law over here, right, where the governments are saying that okay, let the contract come under general principles of law to make the investors feel better. But these people who are advocates of government's freedom, they say that these administrative contracts and this phenomena of administrative contracts, it does come under, it constitutes a general principle of law. It itself is also a general principle of law. This is something which is pervasive, let's say, in all the civilized nations, and everyone recognizes it, etc., right? Because he says here, general principles of law, a set of legal principles or rules shared by the world's major legal systems, right? So this is what they are implying over here. So now the author says, however, their argument is flawed on at least two counts. So now he says that whose their argument, whose argument is he talking about? He's talking about the argument of the advocates of government. Because right before this, he has given the argument of the advocates of the government, right? And then he says, however, their argument is flawed on at least two counts. So basically, if I just think about the structure of this first passage, what does it say? It tells us, first of all, it tells us what the developing countries get into these contracts with investors, but then the risks that the investors face. So that is more like context, essentially. Then it tells us that what the countries are doing so that the investors feel more comfort, right? They say that the contracts come under general principles, but then the advocates of the government's freedom, they say that these administrative contracts which give special powers to the government when government gets into these kind of agreements, they are actually a part of the general principle of law, right? But our author says, but their argument, but the advocates are wrong, their argument is flawed on at least two counts. And then most likely now he's going to give us the two counts. And if I see, look at these two paragraphs, I have a first and I have a second. So now he tells us that why the advocates of the government's freedom are wrong, right? They are saying that these contracts are under administrative contracts, which is under the general principle of law. But now the author is saying, but their argument is flawed, this is not correct, and I'll tell you why. And he starts with his two counts. So first, in French law, not all government contracts are treated as administrative contracts. So we were given over here somewhere French law originated in French law. He said administrative contracts, a concept that originated in French law, right? So he says in French law, not all government contracts. So not that if a government is making a contract, it is automatically an administrative contract. He says that's not the case. Some contracts are designated as administrative by specific statute, in which case the contractor is made aware of the applicable legal rules upon entering into agreement with the government. So, I can think of, let's say, if it is a contract with a foreign investor to make a nuclear power plant, right, that could be considered an administrative contract where the government has more power than the investor has. I mean, I kind of get it, right? It's about the safety of the nation and everything. So he's saying some contracts are designated as administrative by specific statute. So it's possible that, let's say, all nuclear power plant contracts are considered to be administrative, where the government has the power to, change, modify it, or even, not have the, maybe whatever this terminate the agreement or whatever, right? The government has the power to do whatever it wishes to. So some of them, he says, they are considered. Now, and in which case the contractor is made aware. So the foreign investor has to be made aware that it's going to be an administrative contract. In case you are going to invest in a nuclear power plant, then please be assured that ensure that you understand that it's going to be an administrative contract. So the government has extra power, right? Then he says, or alternatively, the contracting government agency can itself designate a contract as administrative by including certain terms not found in private civil contracts. So he's saying, or it is also possible that the government agency can itself say that, okay, we are going to, have a contract with so and so investor, but this is going to be an administrative contract, and then they can include certain clauses that, for example, the clauses in the contract could be that the government is allowed to modify the contract when it wishes to, etc. So those clauses have to be included in the contract, and then they can become administrative, right? Now, and these terms are, of course, not found in the private civil contract. So, what do we understand by private civil contracts? Now, this passage is something that anybody with any background has to be able to understand, right? So, then just take it on face value. When it says private civil contracts, then I would say that those would not be between the government and another party. They would just be between private individuals, and hence it has to be fair to both, right? So those clauses would not be a part of normally a part of private civil contracts, but they can be added specifically, and the contract can be made administrative in that sense, where the government has more power, right? Moreover, even in the case of administrative contracts, French law requires that in the event that the government unilaterally modifies the terms of the agreement of the contract, it must compensate the contractor for any increased burden resulting from the government's action. So he's saying that, and even if the government does modify, the government has to compensate the contractor, has to whatever, provide financial incentive or whatever to the contractor to ensure that he is not facing a lot of loss, right, to the investor in this case. In effect, the government is thus prevented from modifying those contractual terms that define the financial balance of the contract. So he says, so effectively, because the government will need to then provide compensation, etc., to the contractor, so the government doesn't modify on an ad hoc basis, right? It will do it only in case it can pay that, and of course, this sum will be really large. So of course. So he's saying that, don't think of administrative contracts as any contract that the government does. So he's explaining us why their logic, the logic of the advocates of the government's freedom is not valid, right? He's told us how it is flawed, as when we're discussing administrative the agreements, by their very very definition, why it is not what you think it is, right? This is what he's telling. All right, then he gives us a second point why their logic is flawed, the logic of the advocates. Second, the French law of administrative contracts, although adopted by several countries, is not so universally accepted that it can be embraced as a general principle of law. So, secondly, he's saying, all right, whatever the administrative contracts are, for example, even if you like put them aside for now, I've explained you what they are, and I've told you they are not what you think they are. And even if we say that there is an administrative contract, the point is that it is not accepted as universally as it should be, because these general principles of law recognized by civilized nations share, a set of legal principles or rules shared by the world's major legal systems. So major legal systems have to agree to it, are sharing these, right? But administrative contracts, they are adopted by several countries, but they're not so universally accepted that they can be called general principle of law. So basically saying administrative contracts cannot be called general principles of law. They can't be under general principles of law. In both the US and the UK, government contracts are governed by the ordinary law of contracts. So he's saying in these two countries, government contracts are not administrative contracts. They are ordinary law of contracts, right? Regular contracts, just like you have contracts between any two people, with the result that the government can reserve the power to modify or terminate a contract unilaterally only by writing such power into the contract as a specific provision. So he's saying if government wants extra power, they need to write it in the contract. They don't just inherently get it because they're the government, right? They have to specify that. But when it is written in the contract, the other party automatically knows it because they have read the contract before signing, of course, right? Now, indeed, the very fact that termination and modification clauses are commonly found in government contracts suggests that a government's capacity to modify or terminate agreements unilaterally derives from specific contract provisions, not from inherent state power. So here he says that, the very fact that termination modification clauses are commonly found. So he's saying in government contracts, you commonly find these clauses where they specify how the government can modify the agreement, or how the government can terminate the agreement. So he's saying, since these clauses are normally found in contracts, it means that the government doesn't have an inherent power, right? Because if it was inherent, if it was obvious, if it was already known that the government has this power, they didn't need to really write it down in the agreement, in the contract, right? He's saying that these clauses are found in the contract shows that they are not inherent. They need to be specifically mentioned in the contract. So these are the two reasons. These are the two reasons why he says that the logic that is given by the advocates is not correct. Right? Do you understand the passage? Any doubts in the passage? Now let's look at the questions then. So we have, first of all, we have universal questions. Yeah, the passage is right next to it. So I'll give you 3 minutes. Try out the two questions. Then we'll discuss what universal questions are. Okay, let's discuss this. Because in universal questions, what are universal questions? Which are based on your overall understanding of the passage. So once you've understood the passage really well, in universal questions, you don't really need to go back to the passage, right? So hopefully we've understood the passage very well. Let's see if we can answer the questions, and if you understand the various given options and why the correct is correct. Yeah? So in the passage, the author is primarily concerned with doing which one of the following. So basically, he's saying in the entire passage, what is the author trying to do, right? What is he trying to, give us, right? So, what is he primarily concerned with? Option A, pointing out flaws in an argument provided in support of a position. Look, now this sounds reasonable to me. Why? Because he does point out two flaws in the argument. What was the argument provided in support of a position? What is the position over here? That the government has additional, right? And what was the argument provided in support of the position? That the contracts that the government makes, they are administrative contracts, right? And then at that administrative contracts are general principle of law, and that is why, this is the argument given by the, we told over here, right? Advocates of the government's freedom. This is the argument that they give, and the author is pointing out flaws in that particular argument, right? So certainly sounds reasonable. Let's keep this. B, analyzing the weaknesses inherent in the proposed solution to a problem. So there is no proposed solution to a problem given to us, right? And it even if I consider that this is a proposed solution where they say that the governments are trying to say that the contract will come under general principles of law, he is not giving the weaknesses of the solution, right? He's saying, he's basically giving the flaw in this particular argument which the advocates of government's freedom are giving, right? That he says that, he gives that they're the flaw in their argument. He's not giving the weaknesses in the government's plan of giving, let's say, of having these contracts under the general principles of law. Okay? So this doesn't look good to me. All right. Then marshalling evidence in support of a new explanation of a phenomenon. There's no new explanation of any phenomenon. So let's, of course, just eliminate it. Then analyzing the risks inherent in adopting a certain course of action. Look, he does talk about risks, but he says in the beginning, he talks about the risk, right? That there is economic risk, which is normal economic risk over here, but then there is additional risk as well. But is he analyzing the risks inherent? He just mentions them, gives them as a context, and he talks about how there's additional risk. And then what he's doing in the entire passage is something totally different, right? Again, as we said, most of the passage focuses on pointing out the flaws in the argument of these advocates, right? Okay, so then this is also not correct. Look at E, advocating a new approach to a problem that has not been solved by traditional means. Okay, so then there is no new approach which has been discussed. So obviously this is also not the answer. Hence our answer is certainly option A, right? We don't need to go back to the in universal questions. If we understand what the passage is saying, your first read will be just a glimpse of the passage, just going through it just to understand what it is all about. Then your second read will be detailed. You will figure out exactly what the gist of the passage, what is it saying. So in case you've understood that extremely well, then you don't need to go back to the passage. It is talking about the entire passage as a whole, right? You've already read the passage twice. You don't need to read it again in universal questions, right? Okay, look at question 2. Which one of the following best states the author's main conclusion in the passage? Now, here it said the author is primarily concerned with doing, which what is he doing? So they are very similar questions, just that the wording of the options will be a little different. Here we are saying what is the conclusion. So in case I had to, give one sentence for the entire passage, the author's opinion, what is he trying to tell us? Exactly that one sentence, what would it be? The conclusion of the passage, right? Let's see. Providing that an international agreement be governed by general principles of law is not a viable method of guaranteeing the legal security of such an document. Does he say that international agreement be governed by general principles of law is not a viable method? He is not, again, as we said, right? He's not pointing out flaws. No, he's not analyzing the weaknesses inherent in the proposed solution, right? He doesn't say that general principles of law, having them being governed under general principles of law is a bad idea. He does not say that, right? He is basically talking about how advocates say that, that administrative contracts are a part of general principle of law. That is a problem, right? He's saying that is not okay. So he does he provide that international agreement be governed by general principles of law, that this is not a viable method? No, he's saying that, you know, he's not saying that this is not viable. All he's saying is that you don't have a proper understanding of what administrative contracts are, right? And in any case, he says that administrative contracts do not really fall under the general principles of law. So don't say that under general principles of law, the governments have additional power because all their contracts are administrative contracts. That's illogical. That is what he's saying, right? So he's not against the general principles, right? So again, this is then not the answer. French law regarding contracts is significantly different from those in the US and the UK. This is not his this is not his main aim, isn't it? He does imply that it is different in some ways because administrative contracts are not accepted in US and UK. He says that right over here somewhere. In both US and the UK, government contracts are governed by ordinary law of contracts, right? So they are different. We don't know whether significantly different or not. But anyway, this is not the main aim. This is not the reason he wrote the argument. Okay. Now, contracts between governments and private investors in most nations are ordered by ordinary contract law. Now, most nations, we have absolutely no idea what most nations is. We don't know whether they are or not. He is not saying that normally this is how it happens, right? The very purpose of writing the passage is very different. He's pointing out the flaws of the advocate's reasoning. So again, not correct. An inherent power of a government to modify or terminate a contract cannot be considered a general principle of law. This is what he does imply in the entire passage, right? He does say that inherent power of a government to modify or terminate cannot be a general principle of law, because what the advocates of government are saying, they are saying that the government has an inherent power to modify or terminate, and that this is a part of general principle of law, and that he's saying that is where you're wrong, right? That the administrative contracts are not a part of the general principle of law. His second point is predominantly that only, right? So this certainly seems good. Mhm. Now, contracts between governments and private investors can be secured only by reliance on general principles of law. He does not say that they can be secured only by this, right? There could be other ways in which it could be secured as well. He is just giving us one way in which the countries are trying to secure it by saying that the contracts are governed by general principles of law, right? So, of course, then our answer is D. D is correct. Let's go on to so these were our universal questions where we didn't really have to go back to the passage to look at the answer. If we understood the passage, we know how to solve it. We know what the answer is, right? Everything else was certainly wrong. Okay, now let's look at infer questions. Just give me a moment. Wait. Okay, I hope you can see this now. I'll give you 3 minutes for this. Let's take a look at it. Otherwise, we won't be able to finish the questions. So, question three, the author implies that, okay, first of all, what are inference questions? They are, the answer is not directly given to you in the passage, but we can infer it based on what is given to us in the passage, right? So basically, it's given, the answer is there, but indirectly, right? There are words which help us infer, right? And what we can infer is what should be true based on what is given in the passage normally, right? Okay. Mhm. The author implies that which one of the following is true of economic development agreements. Where does he talk about economic development agreements? He starts the discussion with this, with the, yeah. All right, A. So what is true? He says the author implies that what is true of these agreements. They provide greater economic benefits to the governments that are parties to such agreements than to foreign investors. He doesn't say that they provide greater economic benefits. He just says that in these agreements, investors have additional risk. Again, he's not saying that the investors have more risk than the government. Doesn't even say that. All he says is that regular investors, they have the economic risk, but in these kind of agreements, there is even additional risk that the government will keep the project for itself, terminated, whatever, modified, unilaterally. So that. So yeah, so he doesn't say that they provide greater benefits. We don't know how the revenue is distributed. For example, maybe the investors get more revenue. All right. Then B, they are interpreted differently by courts in the UK than they are by courts in the US. He does not say that. What he says, in both the US and the UK, they are governed by ordinary law of contracts, right? He says that he gives a similarity between them. There is no difference between them given at all. And this is the only place where he mentions US and UK, right? So correct. Now, they have proliferated in recent years as a result of government's attempts to make them more legally secure. Now, do we know that there are more of these that have happened in the recent years, that a lot of these economic development agreements have taken place? No, so we can't say that they have proliferated, that is increased a whole lot, right? In recent years. No, we don't know that, right? So then this is also not correct. He doesn't imply this. We don't know whether they have increased in number, reduced in number, how it has worked. B, they entail greater risk to investors when the governments that enter into such agreements reserve the right to modify unilaterally the terms of the agreement. Now, how about that? He does say that they have greater risk involved to the investor, right? And he says because if the governments they enter into agreements, they reserve the right to modify or terminate, then it does entail greater risk to the investors. So well, he does say that. So okay, let's keep this does look good. Then E, they have become less attractive to foreign investors as an increasing number of governments that enter into such agreements consider them governed by the law of ordinary contracts. Now, law of ordinary contracts, right? What is law of ordinary contracts? What we can infer is that those are the ordinary contracts where the government doesn't have any additional power, right? So then the passage doesn't say that the governments that enters into such agreements consider them governed by the law of ordinary contracts. If this were true, there would be less risk to the investors because then the government is not keeping special powers for itself, right? So they have become less attractive to foreign investors. As an increasing number of governments, they consider them governed by law of ordinary contracts. That is not true, right? Then they would have become attractive to foreign investors in case it were governed by ordinary contracts. Then both, would have equal power, right? Both the parties. So then, of course, this is also not correct. So then our answer is D. It makes sense. It do entail greater risk to investors when the government keeps that power to modify or terminate when it wishes to, right? Correct. Okay. 4. It can be inferred from the passage that under the ordinary law of contracts. Now we're talking about the ordinary law of contracts. Okay, here. A government would have the right to modify unilaterally the terms of a contract that it had entered into with a foreign investor if which one of the following were true. So now we know that the government contracts are governed by the ordinary law of contracts, right? Here he says that with the result that the government can reserve the power to modify or terminate a contract unilaterally only by writing such power into the contract as a specific provision. So when it is an ordinary law of contract, then the government and the investor, they are both equal, just like any other two parties, right? So then, in case the government does want extra power, then it has to write that in the agreement, and the investor has to agree to it. Maybe the investor would take a bigger cut of the finances, whatever may be the deal, that is fine. But then, in case the government wants to retain, if it is ordinary law of contracts, and if the government does want to retain extra power, it has to write that clause in the contract, right? Here we are given this with the result that government can reserve this power only by writing such power into the contract as a specific provision. Yeah, so basically, this is what we are then looking for. So, A, the government undertook a greater economic risk by entering than the no. So, we know that, we don't know if the government did undertake greater economic risk. Then the cost to the foreign investor by abiding by the terms of the contract exceeded the original estimates of such costs. No such discussion of costs. The modification of the contract did not result in any increased financial burden for the investor. Again, no such discussion on the ordinary law of contracts. There is no such discussion, right? It doesn't say that if it is under the ordinary law of contracts, the government can get more power in case the modification of the contract did not result. We don't know that, right? B, both the government and the investor had agreed to abide by the general principles of law recognized by civilized nations. This would not give extra power to the government, right? Because we're saying general principles of law would actually treat them both equally. Right? So then this would not give additional power. And we are saying that under ordinary law of contracts, what would give government additional power? Special powers. The contract contains a special provision allowing the government to modify the contract. Correct. So, as it was written only by writing such power into the contract as a specific provision, right? So, this says the contract contains a specific provision allowing the government to modify the contract. So, this is correct. So, we can infer this. Right? All right. Good. So, now we'll take a look at a function question. What is a function question? Basically, it'll ask you what is the purpose served by, let's say, a specific sentence in the passage or a specific word in the passage, etc. So, what role does a specific sentence or word, etc., play in the passage? Why was it used in the passage? So try out the function question, and this the sixth is a specific detail question. The answer of this will be found in the passage. Ensure that you go back to the passage before answering it, because sometimes you may not recall the correct information. So in specific detail, always go back to the passage to ensure that you've got the right answer. So try these two out. Okay, what is a function question? We've already discussed, right? So let's check this out now. In the last paragraph, the author refers to government contracts in the United States and the United Kingdom primarily in order to. So he's saying that here, right in the last paragraph, he talks about United Kingdom. So he refers to government contracts in these countries. What does he say? He says in both the US and the UK, government contracts are governed by the ordinary law of contracts, with the result that the government can reserve the power to modify or terminate only by writing such power into the contract as a specific provision, right? So he says, okay, and we have to read when we're talking about a function question, we have to read two sentences above it and two below it to understand exactly what role does it play. So here he's giving us the second flaw in the reasoning, right? He says, second, the French law of administrative contracts, although adopted by several countries, is not so universally accepted that can be embraced as a general principle of law. In both the US and the UK, government contracts are governed by the ordinary law of contracts. So essentially, he's saying that administrative contracts are not a general principle of law, right? Because they're not accepted by everyone. Then he gives us an example that in US and UK, the government contracts come under the ordinary law of contracts, not administrative contracts. Okay, so he refers to them to tell us that it doesn't come under, in these countries, it doesn't come under administrative contracts, and that administrative contracts are not general principles because they're not so universally accepted, right? Okay, a side to governments that often reserve the right to modify unilaterally contracts that they enter into with foreign investors. This is incorrect because he says that in these two countries, these contracts, government contracts, are governed by ordinary law of contracts, not administrative, right? So the government doesn't keep special powers. Please support the assertion that there is no general principle of law governing contracts between private individuals and governments. Now, he is not saying that he's not trying to support the assertion that there is no general principle of law, right, governing the contracts between these two. He is saying that administrative contracts are not a part of the general principle of law, right, by giving us an example of these two. Okay, so then cast doubt on the alleged universality of the concept of administrative contract. Exactly. So he says that second, the concept of administrative contracts, although adopted by several countries, is not so universally accepted. So he's saying, allegedly you're saying that it is universally accepted, but it is not. And then he gives us examples how in these countries it is not accepted. Right? So then certainly makes sense. This is the role this mention of these two countries is playing, right? Did he provide examples of legal systems that might benefit from the concept of administrative contracts? He does not say that these countries will benefit from administrative contracts. So, yeah, in fact, it seems like he's happy that these countries do not have government contracts, administrative contracts. He doesn't like that, right? So he doesn't say that they might benefit from administrative. Provide examples of characteristics that typically distinguish government contracts from private civil contracts. So he doesn't give us that example, right? He's not using them to give us example. What is he doing? He's giving them to cast doubt on the alleged universality of the concept of administrative contracts, that they are not accepted that universally as you think, right? Okay, so answer is C. You get 6. According to the author, which one of the following is true of a contract that is designated by a French government agency as an administrative contract? We know where he talks about administrative contract by the French law, so let's go there. Now, in French law, not all government contracts are treated as administrative. Some contracts are designated. Right? He's saying which one of the following is true of a contract that is designated by a French government agency as an administrative contract. So he's saying that some contracts are designated as administrative by specific statute, and and they are made aware of it. And alternatively, the contracting government agency can itself designate a contract as administrative by including certain terms not found in the private civil contract. So this is how the French government can designate a contract as administrative, right? Either it is through a specific statute or it can put some terms in the agreement which are not found in private civil contracts. Right? Okay. Now, it requires a government agency to pay for unanticipated increases in the cost of delivering the goods and services. No cost of delivering, etc., discussed. Chuck it. It provides the contractor with certain guarantees that are not normally provided in private civil contracts. Again, no guarantees discussed. So again, incorrect. it must be ratified by the passage of a statute. Look, he doesn't say that it must be ratified. He's saying that there could be specific statute which could designate it as administrative, right? So he's not saying that it must be ratified. That is, he's not saying that I can make a contract, the government of France can make a contract administrative by passing a statute, right? By ratifying by the passage of a statute. Then, you know, they have declared it legally as an administrative contract. No, he's saying that they are designated as administrative by specific statutes, the statutes that already agree, are already there, right? Because of those, some contracts can be called administrative, but then the government has to tell the investor that these are administrative contracts, or they can make them administrative. How? Not by passing a statute, not by making it a law, but by including certain terms in the civil contracts. Right? So again, this is not correct. It discourages the foreign companies from bidding on the contract. No such discussion. It contains terms that distinguish it from a private civil contract. Exactly. So it contains those terms which give more power to the government. So not unlike a private civil contract where both the parties have equal power, and one cannot make a decision unilaterally. So they make it administrative by including certain terms. We are given this over here by including certain terms not found in private civil contracts. So this is correct. And in case we don't go back to the passage and read it once again, it is quite possible that we might go with this. Oh, we read something about statute, but then please go back and read carefully what was said about that specific statute, right? All right. Two more questions. I do want to discuss all the different question types that we have. There we go. These are your extrapolatory questions. What does that mean? That the answer is not there in the passage. These are, in a way, they could be called infer questions, but these are a step ahead of infer questions. That whatever you've learned from the passage, now you're applying it to situations which are perhaps outside the passage, right? Or giving situations which are outside the passage. So that is why I call them extrapolatory ones. In any case, check them out. I'll give you a couple of minutes. Let's look at them. So the author's argument in the last sentence of the passage. So argument in the last sentence of the passage. Wait, let me just put it up a little. Oh, all right. So would be most weakened if which one of the following were true. So last sentence is the sentence, right? The sentence, not the line. So the entire sentence. So we're saying that the author's argument would be most weakened if which one of the following is true. So he's giving us some information which is outside the scope of the passage. He says that this is what he says, this is what the author argues, right? How can we weaken it? This is like a critical reasoning question, isn't it? We have to provide outside information, new information to weaken it, right? Okay, so what is the author's argument? The very fact that termination and modification clauses are commonly found in government contracts suggests that a government's capacity to modify or terminate agreements unilaterally derives from specific contract provisions, not from inherent state power. So he says, again, we've already discussed this, but he says that the very fact that these clauses are found in these contracts means that the government gets the power to modify or terminate because of these clauses. That is why it puts those clauses there, right? That it is not an inherent state power. Otherwise, if it were inherent to the state, why would the state put those clauses in the agreement? They are found in these modify and terminate agreement. Clauses are found means that they are deriving their power from those particular provisions of the contract, right? They are not inherent powers. Right? Okay, so then so which one of the following? Now, how would we weaken it? How would we say that the fact that these provisions are found in the contract doesn't mean that the government doesn't inherently have the power, right? Okay. The specific provisions of government contracts often contain explicit statements of what all parties to the contracts already agree are inherent statements. So now what if we were told that government contracts, they often do contain explicit statements also, right? That if something is inherent power of the government, for example, if the government is allowed, if everybody knows that the government is allowed to terminate the agreement as and when they wish to, still it is normal to put that specifically in the contract as well. Then the fact that they are found in the contract does not mean that the government doesn't have the inherent power. So now we have weakened the author's statement, right? The author's argument. He was saying that the fact that we found them in the contract means that it was not inherently there, implicitly there, right? The government had to explicitly mention it in the agreement means that implicitly the government did not have this power. But what if it is normal, it is commonplace to put whatever is implicit, whatever is obvious also into words explicitly into the contracts? Then this does not provide us data, then this is not supporting the author's position, right? If it, then we are weakening the author's position by saying that just because you found those clauses in the contract doesn't mean that this government doesn't have the inherent power. It is normal for the governments to put it explicitly as well, right? So then certainly this does weaken the last sentence for sure, right? And this is not something which is found in the passage, isn't it? This is an extrapolate. You have to think about it beyond what is given to you in the passage. Governments are more frequently put in the position of having to modify or terminate contracts than are private individuals. Well, this doesn't weaken this, right? There is no discussion of the contract, nothing. So modification clauses in economic development agreements have frequently been challenged in international tribunals by foreign investors who were a party to such agreements. Again, doesn't matter, right? It doesn't weaken. Look, we're talking about the fact that these clauses appear in government contracts, right? What does that imply? What does that mean? Right? The general principles of law provide that modification clauses cannot allow the terms of a contract to be modified in such a way that the financial balance of the contract is affected. Again, now, does it weaken our position? Does it say that, the whether the presence of the contracts means this? It doesn't, right? So again, not correct. Termination and modification agreements are often interpreted differently by national courts than they are by international tribunal. Now, this distinction is not made anywhere in the passage. So anyway, again, this is not correct. Then, of course, answer is A. As we said that it makes perfect sense that just because it is written explicitly doesn't mean that that inherent power is not there. Right? We do tend to write it explicitly also, whatever is inherent. Right? So we have to be very sure about what we are weakening when we say that we have to weaken, what we do in our critical reasoning questions. We say that we are weakening the conclusion, we are weakening the argument of the author, right? So we have to again focus on this particular sentence and weaken just this. Okay, another extrapolation now. It can be inferred from the passage that the author would be most likely to agree with which one of the following assertions. Now, when the question says author would be most likely to agree with what? Most likely to agree means that the author hasn't written that specifically in the passage, right? This is based on what he has written. This is most likely true, right? Whether it is actually true or not, we can't really say, but based on what the author has written and given, this is the idea, this is what we can, which we feel that this is what the author would agree with, right? So I mean, we can consider it somewhat of an infer question also, but then usually I feel it goes one step beyond infer, right? Infer is somewhere something in which I wouldn't really have a doubt of whether it is true or not, but most likely to be true means that there is a little bit of extrapolation that I'm using there. Yeah. Okay, so again, let's read the question once again. It can be inferred from the passage the author would be most likely to agree with which one of the following assertions regarding the general principles of law. So in the line 8, so he mentions the general principles of law over here, that they are governed by general principles of law recognized by civilized nation, right? And he talks about the general principles, set of legal principles or rules shared by the world's major legal system. Okay? And he gives us that. Okay, so what is he most likely to agree with, right? Which of the following assertions regarding this principle? They fail to take into account the special needs and interests of developing countries that enter into agreements with foreign investors. But no, he doesn't say that. He doesn't, mean that, imply that. He doesn't say that, general principles of law are not, they don't take this into account. They don't take the special needs of this into account. He doesn't really say that, right? Yeah, I don't think he would agree to this. Basically, what he's trying to say is that administrative contracts are not a part of the general principle. General principles are good. The governments are trying to ensure that their contracts come within the general principles. Now, if you are saying that means that the government contracts are anyway administrative contracts and administrative contracts come under general principles, then you are wrong. So what he's trying to say is that general principles are fair, right? Administrative contracts are not a part of that. So then he's not really giving us any kind of weakness of the general principles, right? So then they fail into account doesn't really work very well with what is given to us, right? So we can't really say what he feels about this. So let's just ignore this. Okay. They have only recently been invoked as criteria for adjudicating disputes between government and foreign investors. Whether they have been recently invoked or he doesn't talk about the timeline, etc. So then, and disputes, he anyway doesn't discuss disputes. So then I really can't guess anything about what he thinks about this thing, right? So then again, let me eliminate it. They are more compatible with the laws of France and the United States than with those of the United Kingdom. Now, they are more compatible with the laws of France and US. He's clubbed into one, and he's distinguishing them with those of UK. Nothing of that has happened, right? Here he puts France in one bracket and US and UK in the other bracket. So then I don't know what he really thinks about this. So again, not correct. They do not assert that governments have an inherent right to modify unilaterally the terms of agreements that they have entered into with foreign investors. Now, think about it. What is he trying to say? He is trying to say that general principles do not assert. He's saying that administrative contracts where you give government the unilateral modification and termination power, those are not a part of general principles, right? This is what he's been trying to tell you in the entire passage. So then I think he would agree that general principles, they do not assert that governments have the inherent right to modify unilaterally, right? So this, well, does look good to me, right? They're not useful in adjudicating disputes between developing countries and foreign investors. Again, no disputes are discussed, so I don't know what he thinks about it. So, we've got our answer. We do know that this is what he's been implying. Look, this is not what is mentioned in the passage anywhere, right? He doesn't say that general principles, they do not assert that governments have an inherent right. But this is what he has been implying throughout by saying everything that he has been saying. Right? So again, as I said, we could consider them a little bit to be infer, but they are a step beyond it, right? Your extrapolatory questions. All right. So we have discussed all the different types of questions that are there on this passage. Well, I think it was one of the tougher ones, but then be prepared, because as a manager, these are the kind of situations that you would have to go through, of course. So, you should be comfortable with this as well, right? Good. Yeah, I hope you've understood the various kinds of questions. I'll see you next time, and we'll most likely take a quant webinar next time. Yeah, we'll have a quant class now. Yeah. All right. See you guys next week. Bye.